Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to answer the question, why does Social Security deny so many apparently deserving claims? And by the way, this is one of the questions that I got when I put out a video a few days ago asking you for your suggestions. What is your most important question about Social Security disability? And I had a lot of responses so far. It's only been a couple of days. A lot of great responses, and I figured let me just start answering some of those. Turns out I just got a haircut, and so this is about as good as it's going to get from the way I look, but I figured I'd go ahead and start knocking some of those out, but keep the questions coming. I really appreciate it. So again, today's question is, why does Social Security deny so many deserving claims? And let me break this down into two parts. One is the administrative level, the people at the state agency, the adjudicators, not the judges. Why did they deny so many claims? And then the second part is, why do judges deny so many claims that appear to be deserving? So first of all, regarding the adjudicators, realize that these are non-attorney, essentially paralegals or claims representatives, and they are looking for listing level impairments. In fact, at the initial application stage, about a third of claims are approved, and those are typically going to be cases where somebody is deathly ill, they've got terminal cancer, they've got some sort of a medical condition. It could be a compassionate allowance condition or some other condition that is really life-threatening, but these are listing level cases, and the adjudicators are trained to look for the magic words of the listing. So either the doctor has specifically said this person meets listing 1.04, or the medical record is very clear that the person, let's say it's a cardiac case, is on a heart transplant list. That would be listing level. And so what the adjudicators do is they take the record, if they spot it as being a possible listing level case, they take it to one of Social Security's in-house medical consultants, typically retired or part-time doctors at the state agency office, and they look at it and say, yes, this person meets a listing, we're going to go ahead and issue an approval. If you don't fit in that category, if you don't have a listing level case, or if you've applied before and been turned down, or typically if you're a younger person in your 30s or early 40s, they're probably just going to turn you down because you're probably not listing level, or they're going to assume you're not listing level, and they've got so much going on, so many cases to go through, that they really are only going to look at cases where it just screams that this person meets a listing. So I don't think it's that the adjudicators don't want to do a good job. They don't have time, they don't have the resources to go through the files of every single case to see, is this listing level? Another factor is when they request medical records at the state agency level, if the doctor does not respond to their request, they don't have time to do follow-up. That's why when you fill out their forms and give them the names and addresses of your doctors, it's worthwhile to make a phone call to the doctor and ask, what is the proper address for someone seeking medical records from your office or from your facility if it's a hospital. You want to make sure that they have the right address to request those medical records, and if at all possible, if it's a doctor you know, say, I've applied for Social Security, you're going to get a letter from Social Security requesting these medical records, will you please respond to that? Social Security only pays, I think, $10 for these records, and a lot of doctors get kind of upset about it because they lose money. They have to have somebody on their staff, or they use a copying company, so they may not be so inclined to want to respond to those requests very quickly, but obviously in your case, it's important that they do. So anything you can do to encourage your doctor to respond, that would be helpful. So to summarize, I think at the adjudication level, cases that otherwise are viable get turned down either because the medical record is not complete, because the claimant is young, or they've applied before and been turned down, or the medical record is not very clear that you meet a listing. And the listings, if you want to look at the listings, I've got a website called meetalisting.com. But again, it's basically where Social Security has identified specific medical problems that on their face are disabling. Now, let's turn to the hearing side of things. Why do administrative law judges deny claims that appear to be pretty viable? Well, I think there's a couple reasons for that. One is it's just a general arbitrariness of judges. If you look at sites like disabilityjudges.com, you will see that in one hearing office, whatever hearing office you're at, if there are 15 judges, you may have one judge that approves 75%, the next one approves 15%. I've long had a problem with this because I think that's kind of a lottery. It really shouldn't be that way. But Social Security does not really require judges to conform their decisions to any sort of standard deviation. So again, you can have this wide variation. You pick the wrong judge, you're probably going to lose, or you get assigned the wrong judge, you're probably going to lose. So there's a certain arbitrariness to it. I think that some judges have a very, very limited view of what it takes to be disabled. In their mind, maybe because of experiences they've had with themselves or relatives, if you have a certain, let's say you have back surgery, there's no reason why you couldn't be back at work within 6 months or 3 months. So sometimes there may be a little bit of an unrealistic expectation by judges, not recognizing that if you don't have gold-plated insurance and you don't have time and resources to go through rehabilitation, you may not get the same results. If you don't have access to the best doctors, you may not get the same results. So I think sometimes you have judges that don't really get it. And again, other times it's just the judge doesn't really have any, or has a different view of what it takes to be disabled. I think there's peer pressure within a hearing office. New judges learn from the older judges. And so when they discuss cases, they're sort of trained by the judges in their hearing office that, this is what you kind of need to have a winning case. Example, in mental health cases, I'm finding that unless I see in the record multiple suicide attempts or inpatient psychiatric hospitalizations, very, very difficult to win a depression case. Well, that's not written anywhere, but that's simply the way judges are interpreting it. Realize, in defense of the judges, who I think by and large mostly want to do a good job. I think almost all of them do that I've run across. Very few, I think, are just really jaded about the whole process. They see people all day long that come in and say, I'm disabled. And so it's easy to get a little bit cynical about that. There's also pressure on the judges. I mean, their decisions are reviewed by the appeals council. And if a judge gets reversed too many times because the appeals council says you're approving too many cases, then that judge loses his or her job and their pension, and then all of a sudden they've got to go try to find a job and try to explain to a potential employer that you got fired as an administrative law judge. There's pressure from Congress, and whether that's direct or is implied, I don't know, but there are videos, you can go to YouTube and you can see where Congress is grilling certain judges for approving too many cases. Well, no judge wants to be on that hot seat. So there's sort of a built-in implied pressure on judges to only approve people who are clearly disabled, and not to give people really the benefit of the doubt, because if a judge starts approving people based on their testimony, you come in and say, I have chronic pain, my knee hurts, my shoulder hurts, my back hurts, but the MRIs show nothing. The CT scans show nothing. There's no nerve conduction tests show nothing. But you're really in pain. And maybe the judge really does believe you. Maybe your doctors believe you. But if a judge approves a case like that, the risk is that he or she is going to get reversed. And again, that goes against that judge's record. So there's pressure, and I think the pressure is downward to really limit approvals to cases where there's objective medical evidence to document that there is something really going on. I think judges at hearings, some of them want to present a very firm and stoic, objective appearance, so that they are, so that people don't assume anything. Again, some judges are just really inherently nice people, and even if they're going to turn you down, they're going to be really nice to you. Other judges want to keep kind of a distance. And again, I don't blame judges for that. I fully respect a judge who wants to keep a professional distance. I don't think it's even appropriate necessarily for the judge to be yucking it up with the attorney or the vocational witness or the claimant. You want your judge to be serious. But I think, again, there's just a lot of downward pressure on judges to deny cases unless the evidence is very, very clear. And again, there is kind of a disconnect in my view about what it should mean to be for a case to be approved. There's a certain subjectivity in there, but like I said, I think that some judges maybe take it a little bit too far. And since there's really no pressure from Social Security to tell judges, you really should be in that 40 to 50% approval rate based on statistical analysis, then I think you find some outlier judges who approve 15 or 20% of cases, although they will still approve cases, but they just are less likely to give you the benefit of the doubt. So I don't think it's that judges take the job because they want to hurt people or deny people unfairly. I just think that there's really no set standard as to what it should take to be approved, and unfortunately that leads to really inconsistent results. And if you happen to draw a judge who has a very, very narrow interpretation of what it means to be disabled, you lose, whereas the guy next door wins. And again, I don't think that's fair, but that's simply the way it is. So I hope that answers the question as to why Social Security appears to be turning down so many viable cases and makes it so difficult. Again, that's the best I can tell you, because there is no definitive answer. The Social Security does not release any statistical analysis, and they certainly, again, don't try to force judges into any kind of range of approvals. I hope you found this helpful. If you did, I would really appreciate it if you would give it a thumbs up on YouTube, like it on Facebook. I've got a website called SSDanswers.com. You can go there and download my Secrets to Winning Disability Survival Kit. A lot of great information there, and I encourage you to access it. I think it's delivered by email. Right now, I think I've got over 30 installments to this survival kit, and I keep adding them. That's why I do it by email, because I can keep adding to it and changing things to keep it as current as possible. But I encourage you to get that. And if you're not already represented, you'd like a free case evaluation, happy to do that as well. Again, SSDanswers.com. There is a form there where you can ask for a case evaluation. So again, my name is Jonathan Ginsberg. I wish you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the survival kit essential reading. Download your survival kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.